I'm Aninka Claassens. I'm the Director of the Land and Accountability Research Centre at the University of Cape Town. I've been a land activist for many years. In 1983 I started working with the Black Sash, helping communities who were resisting forced removals. This paper is about processes of dispossession that are taking place in former homeland areas in Northwest, Limpopo, Mpumalanga, KZN. And it's primarily about post-apartheid laws that have been used to enable these processes of dispossession. The paper focuses on the period in 2000 when the MPRDA, the Mineral and Petroleum Development Resources Bill, was being developed in conjunction with the Traditional Leadership and Governance Framework Act of 2003. These laws combine to treat people living in the former homelands, which is where the mining boom is concentrated, as tribal citizens whose wishes and decisions are subservient to tribal overlordship rather than as full South African citizens. It enables those with mining rights to treat the land rights of people who have lived on land for over 100 years as though they don't exist. What it focuses in on is how these laws have enabled a few politically connected families to amass extraordinary wealth at the same time as the poorest South Africans have seen their land rights dispossessed through processes that do not treat them as being stakeholders whose rights are worthy even of expropriation. Two additional laws that would have made the situation even more stark were defeated because of massive popular opposition to these laws and their approach. One was the Communal Land Rights Act of 2004, which was struck down by the Constitutional Court. The other is the Traditional Courts Bill of 2008, which was defeated in Parliament when the majority of provinces voted against it. These bills have elicited enormous opposition, and that opposition is not opposition to traditional leadership or customary law. Rather, it is based on people saying that these laws entrench apartheid distortions which are completely different from the kinds of accountable, participatory, customary law that they feel protects and upholds their land rights. Because the Communal Land Rights Act and the Traditional Courts Bill did not make it into operation, what we've seen is extraordinary processes of unlawful transactions and the looting of community resources. Government has treated traditional leaders as though they have the land ownership power that the Communal Land Rights Act would have given them, whereas they do not have this power. At this point, the only person with the legal authority to sign surface leases with mining companies is the Minister of Rural Development as the nominal owner of the land, and he must obtain the consent of the people whose land rights are affected in terms of the Interim Protection of Informal Land Rights Act of 1996. Government has ignored and failed to enforce the protections inherent in the Interim Protection of Land Rights Act, and instead treated traditional leaders as though they have this legal authority. Because they don't, those deals are legally precarious, and we have a slew of laws before Parliament at the moment which seek to provide a veneer of legality to these legally precarious deals. And these new laws, in particular the Traditional and Khoisan Leadership Bill, are much less subtle than the early laws. They are overtly about authoritarian power vesting in traditional leadership. They provide explicitly that traditional leaders can enter into deals with third parties that bind the property rights of people living on the land without their consent or without their consultation. Obviously, a law like that will not pass constitutional scrutiny, which raises the question of why Parliament is rushing these bills through during the build-up to the 2019 election. The only answer can be that this is to protect the specific vested interests of specific business people and politicians who have acted unlawfully in entering into multi-billion rand mining deals. It is extraordinary to me that government can enact laws that so fundamentally and explicitly betray the promise of equal citizenship that rural people voted for in 1994 after the extraordinary anti-Bantustan rebellions of the 1980s and 1990s. What we're seeing is government reaching for law, just as the colonial and apartheid governments did, to entrench structural inequality rather than redress it. And until the ruling party is able to confront the kinds of vested interests that these laws would serve, it can never hope to actually deliver South Africa from the legacy of colonialism and apartheid, because these laws entrench that legacy.